Judge Bennett and Judge McBrayer, I want to welcome Ms. Dotson and Mr. Young, and thank you for participating in this oral argument, which is being live streamed for public viewing. We will conduct the hearing in the same fashion as if we were all together in the courtroom. Each side has 15 minutes, and I understand Mr. Young has already reserved some of his time, and that clock has been established. Unless there are any announcements, I will ask Ms. Dempsey to call the case.
Mark Young et al. Versus H&H Testing LLC et al.
Mr. Young?
Thank you, Your Honor. Pleasure to be with you today, and good afternoon. I'm Bill Young of the Nashville Bar, here representing the plaintiff's appellants in this matter. We're here seeking to reverse the Chancery Court's grant of summary judgment in favor of the defendants, H&H Testing LLC and H&H Testing Incorporated, which I'll refer to in my argument as H&H. A brief background of this case, which is fully set forth in the plaintiff's briefs, I think would be helpful to start this argument. The plaintiff, Wesley Young, the son of the plaintiffs Mark and Karen Young, was unfortunately addicted to opioids, an addiction that has ravaged so many others in our country. From May 2013 to January 2015, Wesley Young received treatment for his drug addiction in California, first at the Acadia House, a residential treatment facility, and then at Transcend Mentoring, an outpatient treatment facility. Wesley's parents, Mark and Karen Young, paid for Wesley's treatment in this facility as well as elsewhere. During the course of this treatment, Wesley Young received a series of checks totaling $85,837.11 from his parents' insurer, Blue Cross Blue Shield of Tennessee. The explanation of benefits, or EOBs, sent by Blue Cross to Wesley Young stated that these payments were for quote-unquote hospital outpatient services, and did not state that the payments were for drug testing of Wesley Young's urine samples taken while he was in treatment at these facilities. Wesley Young then gave these funds to his parents, Mark and Karen Young. The Youngs thought these funds were reimbursement for the various costs of Wesley Young's treatment incurred by Mark and Karen Young, and that's why Wesley Young gave the funds to his parents. 2.5 years after Wesley Young began his treatment, 10 months after Wesley Young's treatment ended, the Youngs received a letter from H&H dated November 4, 2015, asserting that the $85,000 payments belonged to H&H. H&H in this proceeding asserts the money was due H&H as a result of 64 laboratory tests H&H ran on Wesley Young's urine samples. These tests were taken twice a week. These tests were conducted even though the urine samples were initially tested by an instant drug testing kit, and all of these initial tests were negative for any illicit drugs. This is all confirmed by the affidavit of Wesley Young, which is in the record. The Youngs subsequently filed this declaratory judgment action as amended to find that either none of these funds or only $1,216 of these funds were due H&H. The Youngs in the Chancery Court asserted three defenses. Wesley Young asserted these defenses against H&H's claim. First, he asserted that there was no contract, no enforceable contract between H&H and Wesley Young for this drug testing. Second, he asserted even if there were a contract, the services rendered were medically unnecessary. And third, and finally, he asserted that there was no claim for quantum merit because the part of the elements of quantum merit were not met. And even if they were met, the most that could be reimbursed H&H was $1,216. The Chancery Court heard cross motions for summary judgment. And on those cross motions for summary judgment, the Chancery Court granted H&H's motion for summary judgment in favor of the defendants. The Chancery Court essentially found that Wesley Young cannot assert his defenses for two specific reasons. First, the Chancellor found that Wesley Young had signed at least 64 requisition forms that assigned his rights to any insurance proceeds to H&H. Second, the Chancellor found that Blue Cross Blue Shield of Tennessee paid these proceeds to Wesley Young with the expectation that Wesley Young would send these funds to H&H, and that Blue Cross Blue Shield's intent in this matter precluded Wesley Young from contesting H&H's claims to these funds. Accordingly, the Chancery Court established a constructive trust on these funds in favor of H&H. We're here now on review of the Chancery Court's grant of summary judgment for the defendants. It's well established by Tennessee courts that the review is de novo. There's no assumption of correctness on appeal. Furthermore, this court, as previous courts have stated, is required to accept the evidence presented by the plaintiffs as a non-moving party as true, allow all reasonable inferences in the plaintiff's favor, and to resolve any doubts about the existence of any genuine issue of material fact in favor of the plaintiffs. The plaintiffs respectfully submit to this court that the Chancery Court erred in granting a summary judgment motion in favor of H&H. First, and here most importantly, the 64 quote-unquote requisition forms relied upon by the Chancery Court, though extremely hard to read, and copies of those forms are in the record, clearly do not include H&H as a party in the assignment of insurance proceeds provision. Now, the language of those forms, which is virtually the same in all 64 forms, is set forth on page 17 of the plaintiff's brief. And I'm just going to read the first sentence of that. It says, financial insurance authorization. I, Wesley Young, assign my insurance benefits, if any, and authorize any insurance payments directly to V Laboratories or Alair Technology for the laboratory services ordered herein by my petitioner. That language does not include H&H. H&H is not mentioned in this assignment.
Mr. Young, does it matter that H&H is not mentioned? Because Blue Cross, which is indemnifying your clients, only approved the $85,000 payment because it found the billing to be proper. And your clients have not incurred any expense. They've just received a windfall, so to speak. So why does it matter that H&H's name doesn't appear when your clients knew some institution would be doing the testing and that Blue Cross approved that institution's billing?
Two responses, Your Honor, and I appreciate the question. First, Blue Cross Blue Shield's intent is not evident in the record. The only thing that's in the record as far as Blue Cross Blue Shield's intent on this money is a statement of its counsel, which is plaintiffs pointed out in their reply brief. That's not evidence. There's no affidavit of Blue Cross Blue Shield of Tennessee. The explanation of benefits sent to Wesley Young did not contain any statement that he or his parents are required to send this money to H&H. And moreover, and most importantly here, what would really control this matter is the contract, the insurance contract between the insured and the insurer. And that also is not in record. So there's absolutely nothing in the record to indicate what Blue Cross Blue Shield's intent was when it sent this money to Wesley Young. But more importantly, Your Honor, the reason providers of health benefits require a patient like Wesley Young to execute an assignment of insurance benefits is to avoid the situation we have here. When the money is sent by the insurer instead of to the provider, it's sent to Wesley Young and ultimately with his parents. There is no valid assignment of insurance benefits here. That's why providers require patients to execute this document so that they don't have to do what the plaintiffs are insisting that this H&H do in this proceeding, which is prove their entitlement to this claim. Now, there's been much said in the briefs that, well, the Youngs aren't entitled to this money. And that, I think, is the point Your Honor is trying to make. The Youngs are not insisting that this money ultimately will be kept by them other than the cost of this proceeding. It's certainly within the Chancery Court's authority, and the Youngs would expect the Chancellor to do this, to order them to refund this money back to Blue Cross Blue Shield of Tennessee. But as pointed out in our brief, the Youngs feel strongly in this matter. They're spending their own resources here to object to the payment of these funds to H&H. And we haven't gotten to the point of why Blue Cross Blue Shield of Tennessee paid these claims. They paid them to Wesley Young. And once
So
the money was
are you suggesting that AV Laboratories or Millennium Laboratories potentially have a claim to these funds? And if so, why weren't they named in the DEC action?
Well, the letter that was received by the plaintiffs was from H&H, and they are the entity that made the claim to the money. If the money is not owed to H&H, which made the claim to the Youngs for the money, then plaintiff's position is absent the cost of defense of this matter, the money would be returned to Blue Cross Blue Shield of Tennessee. The claims are just not appropriate, should not have been paid in the first place. And we tried to raise, the plaintiffs tried to raise several defenses to these in the Chancery Court. And the Chancellor said, quite frankly, the Youngs could not raise these defenses for two reasons. One, that there was an appropriate assignment of insurance proceeds. We submit there's not, and it's clear they're not. And two, it was Blue Cross Blue Shield's intent, but there's nothing in the record to indicate what Blue Cross Blue Shield's intent was. And Your Honor,
in the record that there's nothing in the record that gives Blue Cross Blue Shield's intent that the Youngs forward the money to H&H.
No, there is nothing. Blue Cross Blue Shield of Tennessee did not indicate when they sent the money or the EOBs to the Youngs that money should be sent to H&H. Indeed, the explanation of benefits, as we previously mentioned, showed that these were for hospital outpatient services, which clearly they were not. These were drug tests that were done, and secondary drug tests at that.
What was the method of Blue Cross Blue Shield's payment? Was it by check?
By check, Your Honor. Yes, a series of checks.
Okay, and are the checks in the record, copies of the checks?
No, they are not. The EOBs, my understanding, are in the record. The explanation.
So we don't know if Blue Cross Blue Shield in making payment reserved any sort of rights.
There's nothing in the record to indicate that they did, Your Honor. And indeed, the only thing in the record regarding Blue Cross Blue Shield of Tennessee's intent is a statement of Blue Cross Blue Shield of Tennessee's counsel, which again is not evidence in this proceeding. I think we've gone through the argument here on why the two reasons that the Chancery Court found were inappropriate for a grant of motion for summary judgment. And having said that, we would next address what the plaintiffs, the defendants spent most of their time talking about in their brief. They tried to say that there was an implied or actual contract between Wesley Young and H&H, and it would be unjust enrichment to allow the Youngs to retain this money. First, we would say that's a factual issue. This Court of Appeals recently in the Lendell v. Hubbs case filed on November 23rd stated and reversed a motion for summary judgment, finding that the credibility of witnesses is totally up to the trier of fact and inappropriate on summary judgment. Finally, unjust enrichment, it would be just as unjust to let the defendants retain these funds if they have no right to them, if they can't prove the right to them in this proceeding. So the unjust enrichment argument cuts both ways.
All right, thank you, Young. We'll hear from you on rebuttal. Ms. Dotson.
Thank you, Judge Clement.
Thank you. Good afternoon, Your Honors, and may it please the court. My name is Margaret Dodson, and I'm appearing today on behalf of the H&H testing parties, the appellees in this case. Your Honors, we obviously see this case quite differently from Mr. Young and his clients and his relatives, but our differences of opinion are not grounds for reversing the decision of the trial court. And I would like to start, Your Honors, by discussing the issue of Blue Cross's intent, because obviously there was a good deal of discussion of that with Mr. Young. And Blue Cross's intent here is absolutely clear, and the court should absolutely consider Blue Cross's answer, which is in the record. The Youngs are asking this court—
Is a pleading a factual statement for purposes of evidentiary assessment?
It is not a piece of evidence, Your Honor, but in terms of ascertaining Blue Cross's intent, which here the Youngs are arguing that there was a valid assignment and that assignment is based on the intent of the assignor. And the Collier case that they cite holds that with respect to an assignment, intent is to be determined from, quote, all of the circumstances, including words and conduct. So here, the Youngs are asking this court to completely ignore Blue Cross's filing, and then they have the audacity to go ahead and argue that they are uniquely able to ascertain Blue Cross's intent out of thin air and have conveniently determined that Blue Cross somehow intended to transfer its rights to Mr. Young to come to challenge these payments. This is, of course, Your Honors, completely contrary to Blue Cross's stated intent in its answer. Blue Cross's words and conduct unequivocally point to only one outcome, and that is that this money belongs to H&H Testing. Blue Cross's answer is signed by its counsel under threat of Rule 11 and is an officer of this court. And that filing confirms that Blue Cross sent $85,000 to Mr. Young to give to H&H Testing for covered services, and that in doing so, Blue Cross acted consistently with its policy for reimbursing out-of-network providers.
Did Blue Cross tell them that the money should go to H&H?
I'm sorry, Your Honor, did Blue Cross tell the Youngs?
Tell the Youngs, yes.
Well, Blue Cross sent 64 EOBs listing H&H Testing as a rendering provider and listing the amounts owed for the services provided, and then provided the Youngs with a check for the exact same amount of money that is provided for those services. So, in doing so, Blue Cross has indicated in its answer that it acted consistently with its policy for reimbursing out-of-network providers.
Well, yes, but they may not have known Blue Cross's policy. I'm interested in knowing how they're supposed to know. And the EOBs did not specify, did according to Mr. Bill Young here, that didn't specify that it was to go to H&H.
Well, Your Honor, I understand the question, and there certainly has been.
I'd like to understand the answer.
Well, Your Honor, the EOBs themselves are one of many ways in which the Youngs have notice of H&H Testing.
Okay, so the EOBs did say something about H&H testing? H&H testing?
They do. They list H&H Testing, Your Honor, as the rendering provider, and then show the amounts paid for services rendered to those providers. So they do very clearly list H&H Testing, and they're listed 64 times on the 64 EOBs that Mr. Young received.
So is H&H Testing listed on any of the requisition forms?
Your Honor, it is listed on certain of the requisition forms, yes. And so, it is certainly our position, Your Honors, that these forms create an express contract between H&H Testing and Mr. Young. But in reality, Your Honor, the content of these forms don't really matter for purposes of this appeal, because the Young's arguments on this appeal focus strictly on whether Blue Cross assigned its rights to Mr. Young and whether the Chancery Court should have acknowledged that assignment. And so the court can certainly rule on this appeal and rule in favor of H&H.
Would you say that again? I'm trying to process what you just said.
Of course, Your Honor. The content of these forms does not really matter for purposes of this appeal, because the Young's arguments on appeal focus strictly on whether Blue Cross assigned its rights to Mr. Young and whether the Chancery Court should have acknowledged that assignment. That is what their brief talks about. It claims that the Chancellor erred in failing to allow them to assert certain defenses. And that is absolutely not what happened in the Chancery Court, Your Honor.
Do the requisition forms explain to the patient the battery of tests that will be run on this sample?
And I'm sorry, Your Honor, is your question whether the forms list all?
How does a patient know? Obviously there's various tests that can be run on a sample, and I would assume all those would have varying cost associated with them. So how does the patient know on the front end when they're submitting their sample for testing, how expensive the test is going to be or the scope of the test? How are they informed of that information?
Well, Your Honor, the patients at Transcend are informed of this information and of the testing procedures during the admission process. They're informed by the letter in the admission packet that Mr. Young received describing the role that H&H Testing would perform. And then they're made aware again at testing, signing requisition forms that assign these benefits, these insurance proceeds, over to third parties. Your Honor, the Youngs have complained about the content of these forms throughout the litigation. So, I certainly understand the focus of them. But at the end of the day, even if these forms do not create an express contract between H&H and Mr. Young, which we certainly believe that they do, H&H is still legally entitled to these funds under the various theories set out in our brief, including a contract implied in law, quantum merit, unjust enrichment, and conversion. These forms are simply not required for H&H to prevail on any of these theories, and the court can, of course, affirm on any grounds. So while these forms have been a focus, the content of these forms is no way dispositive in this case. And the undisputed material facts in this case show that Mr. Young was a patient at Transcend, and that as a patient at Transcend, he agreed as a condition of his treatment to submit to comprehensive drug testing. He submitted at least 64 samples for drug testing, that he signed these forms that assign his rights to insurance proceeds, that H&H tested these tested these samples and billed his insurer, Blue Cross, for these services, and that Blue Cross reviewed those claims and issued 64 EOBs to Mr. Young, listing H&H testing as a rendering provider, and that Blue Cross sent more than $85,000 in insurance proceeds to pay H&H testing for these services. And instead of giving the money to H&H testing, the Youngs kept the money for themselves and filed this lawsuit.
I'm assuming since H&H is out of network, the reimbursement wasn't for the full billed cost for the test. Is that correct?
I believe that is correct, Your Honor.
So is H&H waiving any claim beyond what the insurance covered?
We certainly are not intending to waive any claims, but our claims are, as stated in our complaint, are as against the Youngs for the money that was paid directly to them by Blue Cross, and that is due and owing to H&H testing.
I would have thought you would have had to raise as a compulsory claim the funds or the cost of services in excess of the insurance coverage. No? Why not?
Your Honor, we just want the money that was paid from Blue Cross to the Youngs. We have been waiting for this money for 4 years. The Youngs initiated this action and are holding on to this money despite admitting that they have no legal right to it. They have admitted this multiple times and now to multiple courts. And on these undisputed facts, Your Honor, the Chancellor reached the only viable conclusion in law or in equity and held that this money lawfully belongs to H&H testing. The Youngs still refuse to give up this money, despite admitting that it does not belong to them, and despite Blue Cross and the Chancery Court telling them that it belongs to H&H testing. These facts are completely unavoidable, and the Youngs are unable.
Aren't they willing to pay it back to Blue Cross? Did I not hear Mr. Young say that? And let Blue Cross pay whoever? They just don't feel H&H deserves this money.
Your Honor,
they filed the lawsuit. That seems to be pretty up and up to me.
Your Honor, the Youngs filed the lawsuit, and we responded to that lawsuit for the money that was due and owing to us. And certainly, if the services that H&H rendered are good enough for Blue Cross, who reviewed and vetted these claims and has every reason not to pay for services submitted on behalf of its insured, then that should be good enough for the Youngs. And the Youngs should see this, the court should see this argument that the Youngs are making, that they filed this litigation out of the goodness of their heart and in order to fight on behalf of Blue Cross for what it is. It's a last-ditch effort by the Youngs to hold on to this money by recasting their motives on appeal. Your Honor, Blue Cross can fight for itself. It is a massive company. It's the largest insurer in Tennessee, and it has entire departments focused on claims adjudication. And as I said, it has every incentive not to pay claims submitted for services rendered to its insured. The Youngs do not.
Mrs. Dotson,
Yeah.
you said the Youngs admit that they have no right to this money. How and where and when have they made that admission?
Well, Your Honor, they've admitted it in the trial court in their briefing. They've admitted it in this court in their briefing. Their briefing says that it doesn't matter if the plaintiffs have a right to this money. It matters if the defendants do. It matters if we do. And they've admitted just now that Mr. Young just said that they would pay this money back to Blue Cross, which is the first time we've heard that. Their briefing says that they would pay this money back to Blue Cross if Blue Cross came and asked for it. But Blue Cross has said unequivocally, we're not participating in this litigation. We're not going to have anything to do with this case. And so the Youngs fully expect that Blue Cross is not going to come asking for this money, and they fully expect that they're going to be able to just hold on to it, just as they have been for the past 4 years.
If the plaintiffs have admitted that they have no right to this money, would not that raise the question of standing? That what standing do they have to be involved in the rest, the litigation of who is entitled to the rest of the money?
Well, certainly, Your Honor. We've been wondering what we're doing in this litigation for 4 years, and so certainly the Youngs are the ones with this money, and the Youngs are who we are trying to get this money back from.
This almost seems like an interpleader action. The Youngs basically say, it may not be our money, but who do we pay it to? We don't think these people, H&H, should get this money. So, we kind of like to know what we should do.
Well, Your Honor.
Isn't that what they're doing?
Your Honor, the Chancery Court recognized that Blue Cross was a necessary party to this action, and they asked the Youngs to join Blue Cross to this action. And Blue Cross appeared, and they made it unequivocally clear that this money was due and owing to H&H Testing. There is no question about that in Blue Cross's filing. And there is no question that they paid this money to the Youngs to be remitted to H&H Testing, period. So the Youngs cannot continue to hold on to this money. They don't have a right to it. Blue Cross has told them what to do with it, and the Chancery Court has told them what to do with it. And that's what needs to be done, Your Honor.
Did H&H ever bill Mr. Young directly?
No, Your Honor. They submitted claims to the insurer, just as they informed him that they would in the opening letter, and just as the requisition form.
So there's really no way in this case for Mr. Young to do what exclamation of benefits are intended to do, is to get you, the insured, to compare the benefits versus the bill that you receive from the provider.
Your Honor, the EOBs clearly list H&H Testing as a rendering provider. Mr. Young did not ask any questions to Blue Cross as to what those services were or what was provided. And Your Honor, we sent demand letters to the Youngs listing the EOBs and listing the exact amounts that were owed under those same EOBs. So it's very clear that Mr. Young had notice of the amounts that were due to be paid over to H&H Testing based on those EOBs.
Thank you, Ms. Dotson. We'll now hear rebuttal from Mr. Young.
Thank you, Your Honor. Briefly, first on the question raised by Judge McBrayer, I would respectfully disagree with Ms. Dotson. Actually, Blue Cross Blue Shield of Tennessee paid 100% of these out-network claims, and that's reflected in the record, 100% of the cost. Ms. Dotson also claims that Blue Cross Blue Shield's intent is clear. I would again reiterate, there is no affidavit, there's no deposition, there's no writing from any Blue Cross Blue Shield official in the record evidencing what Blue Cross Blue Shield's intent was. And the best evidence of this, the contract between the insured and insurer, is not in the record either. The Tennessee Supreme Court in 2010 specifically stated, and this is in our reply brief, statements and arguments of counsel are neither evidence or a substitute for testimony. All that's in the record is statements of Blue Cross Blue Shield's counsel. That is not testimony. It cannot be relied upon to show what Blue Cross Blue Shield's intent is. In any event, our position is Blue Cross Blue Shield's intent is irrelevant in this proceeding. The defendants don't
Young,
have,
have your clients admitted that they have no right to this money?
Your Honor, other than reimbursement of counsel fees for defending this matter, we are in the position of basically an interpleader. Because if indeed Blue
Then
Cross,
what right do you have to argue as to who gets the money?
well, several reasons, Your Honor. One, payment of these sorts of claims, if they're inappropriate, affect insurance premiums, which would be the insurance premiums of the Youngs. Second, if Blue Cross Blue Shield of Tennessee for any
Do
reason,
your clients have standing to argue the rights of insurance premiums?
when it affects their insurance premiums, yes, Your Honor.
Isn't that a real attenuated argument?
Well, and the second reason would be that if indeed Blue Cross Blue Shield of Tennessee were to ever seek to recover these funds, then the H&H would go after Wesley Young for his share of the payment. So Wesley Young.
Didn't Blue Cross file an answer saying it makes no claims to the money and nobody's making a claim against it?
As of today, that's their position, but Blue Cross Blue Shield of Tennessee could certainly change its mind down the road and seek reimbursement of these funds if they agree, as we feel, that H&H is not entitled to these funds. And then H&H.
Well, they'll have
Again,
it. We have a hard time after appearing in a case and saying we don't want any part of it, though.
They may, Your Honor, but I think the issue here is not whether the Youngs are entitled to the money. It's is H&H entitled to it. They don't have a
What
valid
right do your clients have to say H&H has no right to the money?
because the contract is between H&H and Wesley Young. These benefits, if they were provided to anyone.
But your client has said he and his parents have no right to the money.
We do have a right to seek reimbursement for the cost of this proceeding. We're necessitated by Blue Cross paying the money to us, to the Youngs, as opposed directly to H&H. The money sits with the Youngs. If H&H has a claim to the money, they have to prove they have a legal right to it. It is, in essence, an interpleader case at this point.
Thank you, Mr. Young and Ms. Dodson, for your arguments. We will take this matter under advisement. Ms.
Thank you.
Dempsey.
This honorable